a question that attorneys and judges often ask is, can we really randomize this work that we're doing? Is that ethical? Is that the right thing to do? How can we provide resources to some people and not others? The two things that I come back to time and time again are the fact that we're talking about scarce resources. In every study that we're conducting, we're working with practitioners who cannot provide resources to 100% of the people that they want to serve. So in some way, in one way or another, practitioners are already limiting the resources that they're providing. And what we're asking is that people provide those resources in a randomized fashion, which in a lot of instances people find to be more fair. And the other concept that's important when thinking about self-help materials or other services or legal interventions is we really don't know whether they work. And if we're really in that state of not knowing whether they make a difference, we can feel confident that we're not depriving anyone of something. If we know for sure that giving someone a self-help packet is going to affect the outcome of their case positively, we don't need to study it. The point of these studies is to find out what works. So we're in a state of equipoise, of really a neutral position of wanting to know whether something works and not actually knowing yet. And that's the whole point of the study.
Science and law. I'm a JD PhD student in law and psychology at Yale, and while I'm very involved in the behavioral science movement, I had noticed that there seems to be a big gap. Many people who study judgment, decision-making, all of this decision science, seem to be really focused on how to get people to save, health issues, like how do you get people to show up for cancer screenings and things like that. And it seemed like there was a gap in terms of looking at behavioral science and law. And a lot of insights I thought could be applied to law. So for instance, how do you get people to show up for their doctor's appointment seems not so different, perhaps, than how do you get people to show up when they're summoned to court. And so I thought this is an area where we have a lot we could be contributing, and I didn't see that many people who were working on it, and Jim really stood out.
So regardless of what the project is, whether it's in the civil realm or the criminal realm, we are at the forefront of both the academic study of the law and hopefully informing practitioners about how they go about their business. We're not there to tell them what to do, we're there to tell them what among the menu of options really seems to be the most effective and the most efficient in terms of the use of resources. So ever since we started the lab in the summer of 2016, I've been nothing but excited and nothing but grateful to be a part of this important movement.
Hi, my name is Heidi Liu. I'm a JD PhD student here at Harvard, and as a law student, the lab has been a place where I can connect ideas from my 1L doctrinal classes to real-world situations. And so that's not just at a high level, so like not just thinking about what policies or rules might be implemented, but also at a low level, so thinking about how individuals are affected by those policies. So an example of that might be the PSA study that I'm working on, which has implications for criminal justice very broadly, but through the lens of an individual defendant's particular experience and how their experience is affected by that policy. So we talk a lot in law school about what should we do, what sort of rules to apply. The lab is a space where we think about whether those rules work, and we don't just speculate about them. And the methodology that we use, it's rigorous. It can help to answer a bunch of different questions that are interdisciplinary, and they can also be applied to a bunch of areas in different parts of law. So it's really exciting to be part of this endeavor.
I've been working with Jim Greiner since he first arrived here at the law school about 10 years ago. As his faculty assistant. And over the course of these years, I've seen the idea of an access to justice program become a reality. I've seen a steady stream of very talented research assistants, students here at the law school who have dedicated themselves to developing and implementing all the various random control trials. And it's been very exciting to see. since joining the lab, I've continued to witness the hard work and dedication in developing solutions that will ultimately lead to, all people having access to justice.
The importance of the lab's work really became apparent to me working at a court service center, so helping people for 15 or maybe 60 minutes with a variety of different cases and different types of help, whether it was helping them understand a legal proceeding, understand child support, or how to file an answer for a certain type of case, or how to fill up guardianship forms. And so helping people with these sorts of proceedings, you see what's difficult for people to understand, how nuanced the law is in certain places, and also how frustrating it is that there isn't kind of like a body of research to tell you what kind of help will be the most effective. So if I were to spend time making great self-help material, would that be better and more helpful for someone than spending 20 minutes face-to-face describing a situation to them, describing a legal proceeding? And would that free up time to allow us as a group to triage better? And if we're designing self-help material, what's the best self-help material? What's going to be most effective? What does that look like? And so I think the lab really is diving into a lot of interventions and studies that fill in these huge kind of knowledge gaps, I guess, as to how best to provide services and what.
So the Access to Justice Lab is a self-funded organization, entity, within the Center on the Legal Profession at Harvard Law School. And it's designed to try to serve two primary purposes. The most important one is to try to provide really rigorous evidence of what works and what doesn't in access to civil justice and in court administration, including criminal law. So everything from self-help materials to the effectiveness of legal representation, to the effectiveness of pretrial criminal risk assessment scores or other risk assessment scoring systems in the criminal justice process, all of that sorts of things, anything about what works and what doesn't inside the world of access to justice and criminal and court administration is within the set of things that we do. The second one is to try to break down what we perceive to be the really fierce resistance within the legal community to the practicing legal community to rigorous empirical evidence, especially via the randomized control trial.